Good morning, everyone. We're here for the criminal motion hearing docket this morning. Mr. Stewart, are you covering this docket? Or is Ms. Bonilla?
No, Ms. Bonilla.
Okay, looks like she's on Zoom. Give me a moment. I don't know if I'm having Zoom problems or if Ms. Bonilla is.
Good morning, Your Honor. I apologize. I've been in contact with Miss Bonilla. She said that her computer is a little slow to start up, but she's trying to log on.
I don't have Ms. Bonilla on Zoom.
Judge, think I'm ready to begin.
All right.
Dennis Terulli.
All right, Dennis Terulli, case number 20MM1890 with Mr. Roystock. All right, I believe this is a state's motion to revoke bond.
Yes. Good morning, Your Honor.
Good morning.
Appearing for the defendant, Bruzel Roystacker. Judge, I was notified of this hearing, I think maybe mid-afternoon, when I first saw that counsel had emailed me and we discussed the possibility of this hearing last week. In any event, I reached out to my client. I did inform him of the time and the purpose. I would be, however, according to the rules, the statute actually, and case law, that there is on a first hearing of this sort a request, and I don't know if it's mandatory or not, perhaps it isn't, but under the circumstances here and under the short notice, I tried to prepare for this as best I could. I was in my office very, very early and up late last night. Judge, I'm going to ask for a 5-day continuance in this matter, and if you do the arithmetic, I guess that falls on, it says 5 days under exceptional circumstances, the 5th day, and we certainly have extraordinary circumstances here. Today is Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday. It's a long holiday weekend, and under the circumstances, I would ask for a 5-day continuance on this matter.
Mr. Stewart.
The statute says by right that, or what I read, that by right that they have, I think it uses by right, they have a 5-day continuance. And I had read that also the defense is certainly entitled if they have by right, and I was just notified after 3 o'clock in the afternoon yesterday.
All right, are you done, Mr. Roystocker?
I am.
All right, thank you. Mr. Stewart?
Okay, Judge, so as the court knows, the court always can revoke bond sua sponte from chambers. So, in terms of notice to the defendant, I think sufficient notice has been provided. This was a motion we filed on December 22nd, so a week ago today. And as soon as I filed it, I reached out to your judicial assistant to try and coordinate hearing time. And your judicial assistant promptly replied with this date and time as an option. Mr. Roystocker and I did talk. We never settled on the date, but we did speak. And my recollection is he told me he was going to try and reach out to his client and confirm his client was available. Obviously, with the long holiday weekend, that never happened. But so my concern also, Judge, is this is an issue where, I'm getting word as well from the victim that this continues to occur. It's occurred since the motion has been filed. So, the state's position is it's something that's time sensitive. I think the defendant's been properly noticed. The motion was filed over a week ago. His attorney was put on notice that this could be a potential hearing date and time last week. And if he's not here, then I think the state's entitled to move forward.
Judge, just briefly, yes, as I said, we talked about it. And again, the first time that I was notified that there would be a set hearing was mid or late afternoon yesterday. The stakes are large here, and I certainly want to be absolutely prepared with my client seated next to me, and not have to get things together as quickly as possible. The judge, he has no history of any flight whatsoever. He has adhered to my request the best he can, and he's reachable. I wasn't able to reach him this morning. He may be en route, maybe not, I don't know. But I do know that he works and he lives in this county. I do think their presentation of their case is going to be frankly, extremely weak in the research that I did. It doesn't even make out the charge of battery.
All right. The defendant's motion to continue is denied. The state is correct. The court can revoke bond at any time, and notice for bond hearings only require 4 hours pursuant to the criminal rules of procedure. All right, state, are you ready to proceed?
Yes, Judge.
Judge, I'm going to ask that it's 15 after 9. I'm going to ask then, if that's your ruling, that's your ruling. I'm going to ask for a short opportunity to reach out to his family because I don't feel comfortable proceeding 15 minutes after 9 without him.
All right, well, we can recall your case. We have other cases in the
Thank you
courtroom.
very much.
All right, thank you. All right, let me go to Ms. Woodley or Ms. Armpriester. Do you have clients in the courtroom that we can address?
We do, Your Honor. If Ms. Woodley has other obligations this morning, so I will defer to her.
All right, go ahead, Ms. Woodley.
Saul Flores Silva, case number 19NM2405. Continue with non-distributed plea of not guilty, entering a plea of no contest to the following agreed upon terms. Following agreed upon terms. This is going to be an adjudication of guilt, court costs, cost of prosecution, public defender fees, no trespass at Bamboo Club, which the address is 12215 Collier Boulevard, Naples. And if you can have 90 days to pay.
All right, thank you, Ms. Bonilla. Sir, will you raise your right hand to be sworn? Will you state your name? Thank you. You can put your hand down. Your attorney has indicated you wish to withdraw your previously entered plea of not guilty, enter a plea of no contest, and accept the state's offer to resolve your case today. That offer again would be to adjudicate you guilty, impose all court costs, including costs of prosecution and public defender fees. The court would order you not to trespass at the Bamboo Club located at 12215 on Collier Boulevard in Naples, Florida. Is that the offer you wish to accept today? All right, I'm gonna let Ms. Bonilla ask you some questions.
You've been charged with resisting arrest without violence, which is the first degree misdemeanor. You understand that the maximum jail sentence is 19 years.
Yes.
So that charge, how do you wish to plead? Guilty, not guilty, or no contest? To that charge, how do you wish to plead? Guilty, not guilty, or no contest? Did you understand the terms of the plea agreement? That is signed a copy of the plea?
Yes.
Do you understand all the rights listed on that form that you will be giving up by entering the plea?
Yes.
Are you entering this into this plea because you believe this in your own best interest?
Yes.
Are you currently under the influence of any drugs or alcohol?
Yes.
Are you taking any medication?
Yes.
Do you suffer from any mental illness?
Yes.
Have you discussed the terms of this plea agreement and the rights you're giving up with this plea?
Yes.
Have you discussed the terms of this plea agreement and the rights you're giving up with your entry?
Yes.
Are you satisfied with your agreement?
Yes.
Do you understand that if you are not a United States citizen, you may be subjected to removal or deportation?
Yes.
Do you understand that if you are deported as a result of this case, there will not be a basis to withdraw this plea?
Yes.
Do you need any additional time to discuss any of this with the counsel?
Yes.
None of the state committee.
Ms. Woodley, we stipulate to venue and a factual basis for the plea. All right, sir, I'll accept your plea, find it knowingly, voluntarily, and intelligently entered upon a factual basis and in your best interest, adjudicate you guilty, impose all court costs, including costs of prosecution and public defender fees, order you not to trespass at Bamboo Club located at 12215 Collier Boulevard in Naples, Florida. We're going to have you step right over here to be fingerprinted. Thank you, sir.
Daniel Barkle, I'm going to withdraw his previous plea of, he's going to withdraw his previous plea of not guilty and turn a plea of no contest today to the following agreed upon terms. He's going to be an adjudication of guilt, court costs, cost of prosecution, public defender fees.
Ms. Bonilla, is that correct?
Yes, Your Honor, the plea offer in this case.
Sir, will you raise your right hand to be sworn by the clerk?
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the truth, and nothing but the truth?
Will you state your name? Mr. Barkle, your attorney has indicated you wish to withdraw your previously entered plea of not guilty, enter a plea of no contest, and accept the state's offer to resolve your case today. That offer, again, is an adjudication of guilt. All court costs, including costs of prosecution and public defender fees, would be imposed. I'd give you 90 days to pay those. If you need more time than that, you have to work out a payment arrangement with the clerk prior to the end of 90 days. Is that the offer you wish to accept today? All right, I'm going to let Ms. Bonilla ask you some questions.
You've been charged with making a legal fraud involving damage to unattended property. Do you understand that the maximum in jail at this time is 60 days in the county jail? To that charge, how do you wish to plead? Guilty, not guilty, or no contest? Did you understand the terms of the plea agreement? Have you read and signed a copy of the plea form? Do you understand all the rights listed on that form that you will be giving up by entering this plea? Are you entering into this plea because you believe that it is in your own best interest? Are you currently under the influence of any drugs or alcohol? Are you currently taking any medication? Do you suffer from mental illness?
Did you answer out loud?
Have you discussed the terms of this plea agreement and the rights you are giving up with your attorney? Are you satisfied with your attorney's advice? Do you understand that if you are not a United States citizen, you may be subjected to removal or deportation as a result of this plea? Do you understand that if you are deported as a result of this case, it will not be a basis to withdraw this plea? Do you need any additional time to discuss this with your attorney? Not as a state attorney.
Ms. Woodley, will you stipulate to venue and a factual basis for the plea?
So stipulated to.
All right, sir, I'll accept your plea. Find it knowingly, voluntarily, and intelligently entered upon a factual basis and in your best interest. Adjudicate you guilty, impose all court costs, including costs of prosecution and public defender fees, and give you 90 days to pay. We'll have you step right over here to be fingerprinted. Thank you, sir.
Kevin Cruz Micah, 20 CT 1831. He's been withdrawing his previous plea of not guilty, entering a plea of no contest. To the following agreed upon terms.
What's the last name?
It's Cruz, C-R-U-Z.
Thank you.
Micah,
Thank you.
in 2018 1831.
Okay, go ahead.
This is going to be an adjudication of guilt, a $1,000 fine, 12 months of probation, early terminate at 4 months if the following are completed. 6 months driver's license suspension. I'm asking for no objection to a hardship license if the DMV deems him fit. 50 hours of community service with the option to buy out. DUI school, appropriate days. Substance abuse evaluation, follow-up recommendation with random testing. Victim impact panel, 10-day vehicle impound, no alcohol, court costs, cost of prosecution, public defender fees.
And the plea offer in this case is correct.
Thank you. Sir, will you raise your right hand to be sworn by the clerk?
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Can you state your name? And sir, your attorney has indicated you wish to withdraw your previously entered plea of not guilty, enter a plea of no contest, and accept the state's offer to resolve your case today. That offer again is to adjudicate you guilty, impose a fine of $1,000, place you on probation for a period of 12 months. You may apply for early termination after serving 4 months, provided all conditions have been satisfactorily met. There will be a 6-month driver's license revocation. Ms. Bonilla, do you have any objection to the court entering its no objection to a hardship license?
No objection.
All right. The court has no objection to obtaining a hardship license pursuant to DHSMB rules. You must complete 50 hours of community service, which you may buy out at the rate of $10 per hour. Complete the appropriate DUI school, 1 victim impact panel, a 10-day vehicle impoundment. There will be a no possession or consumption of alcohol provision. That means you cannot consume alcohol while you're on probation. You cannot have alcohol in your residence. You cannot go to anywhere that primarily sells alcohol, such as bars, taverns, saloons, or packaged liquor stores. You must undergo a substance abuse evaluation, follow all recommendations, and you'll be subject to random testing at your own expense. All court costs, including costs of prosecution and public defender fees, will be imposed. Is that the offer you wish to accept today?
Yes.
All right, I'm going to let Ms. Bonilla ask you some questions.
You've been charged with driving under the influence, which is the first degree. Do you understand that the maximum sentence in jail is 180 days jail? To that charge, how do you wish to plead? Guilty, not guilty, no contest?
No contest.
Did you understand the terms of the plea agreement?
Yes.
Have you read and signed a copy of the plea form?
Yes.
Do you understand all the rights listed on that form that you will be giving up by entering this plea? Are you entering into this plea because you believe that it's in your own best interest?
Yes.
Are you currently under the influence of any drugs or alcohol? Are you currently taking any medication?
No.
Do you currently suffer from any mental health illnesses?
No.
Have you discussed the terms of the plea agreement and the rights you were giving up with your attorney?
Yes.
Are you satisfied with your attorney's advice?
Yes.
Do you understand that if you are not a United States citizen, you may be subjected to removal or deportation as a result of this plea?
Yes.
Do you understand that if you are deported as a result of this case, it will not be a basis to withdraw this plea?
Yes.
Do you need any additional time to discuss any of this with your counsel?
No.
Do you understand that driving under the influence is an enhanceable crime?
Yes.
Meaning that if you commit this crime again in the future, you could receive more jail or prison time, a higher fine, and a longer driver's license revocation period. Under the state condition.
Ms. Woodley, will you stipulate to venue and the factual basis for the plea?
So stipulated, sir.
All right, sir, I'll accept your plea, find it knowingly, voluntarily, and intelligently entered on a factual basis and in your best interest, adjudicate you guilty, and sentence you as previously stated. I'm going to have you step over here to be fingerprinted. You'll need to check in with probation before you leave the courthouse today. It's located on the first floor. Thank you, sir. Good luck.
One more person in the courtroom, Charles Curry.
I'm sorry, what was the name?
Charles Curry, S-9-9-E.
Thank you.
We can have a date for a bench trial.
Okay. State ready?
Jennifer, we just available right now, no.
Thank you.
This is for case number 20-998.
Do you have any witness availability issues?
We do not, as long as it's set after the new year, which obviously will be.
Does the defense have any witness availability issues? How long does each side anticipate the bench trial to last?
Probably an afternoon.
Probably an afternoon. We only have one witness to see one.
Do you have any witnesses other than possibly the defendant?
Possibly my client, and that's it.
All right.
If we have any updates, we will certainly let Your Honor know.
How about January 26th at 1:30? Will that work?
Can I have one moment?
That date was the same.
Does the state intend to seek, this is a first degree misdemeanor, correct?
Yes, Your Honor.
Does the state intend to seek jail time?
The agreement until last, Mr. Cabrera was still in the legal time. We agreed to a bench trial.
Is that correct, Ms. Bonilla?
That is correct, Your Honor. The state is not asking for your time at this time. A plea offer was provided back in July, and obviously it's been declined by defense counsel, so defense is ready for trial, the state is ready for trial.
Okay.
And the 26th will work.
Mr. Attorney, will you raise your right hand to be sworn by the clerk?
You solemnly swear or affirm that the testimony you shall bear shall be the truth, the whole truth, and nothing but the truth.
Yes.
Will you state your name for the record?
Charles W. Attorney.
Thank you, Mr. Attorney. Mr. Attorney, do you understand that you have the right to a jury trial
Yes, Your Honor.
and you're waiving that right? Okay. Ms. Bonilla, do you have any questions for Mr. Attorney about his waiving of his right to a jury trial?
No, Your Honor.
Ms. Woodley, do you have any questions for Mr. Attorney on the record regarding his waiver of his right to a jury trial?
Maybe not.
All right. Okay, January 26th at 1:30 for trial. We'll have Mr. Attorney sign for that.
January 26th at 10 o'clock,
1:30,
at 1:30.
1:30. It'll be a special set. I'll have to tell Julianne.
I've got a couple clients on the list still, but not in the courtroom.
Okay. Ms. Armpriester, do you have any clients in the courtroom?
I do, Your Honor. I have two clients that are set for a plea. We just start with Ms. Anna Vicente, 20 CT 1254.
Yes, I'm reading it.
Secretary, I'm pleased on behalf of Ms. Vicente, 20 CT 1254. At this time, we'd like to withdraw our previously entered plea of not guilty in exchange of her plea of no contest.
I need a moment.
Oh, I'm sorry. I don't hear you.
Thank you.
Ready?
Madam Clerk, do you need to repeat the case number?
Thank you. Okay,
20 CT 1254. Ms. Anna Vicente.
thank you.
Sure. Judge, we'll be withdrawing our previous standard plea of not guilty in exchange for a plea of no contest. In exchange of that plea of no contest,
Mrs. Said will be adjudicated guilty. She'll be sentenced to 12 months of probation, but may early terminate at 6 if all conditions are completed. Conditions of probation is a $500 fine, and 12 months driver's license suspension, complete level 1 of DUI school, participate in a substance abuse evaluation, follow the recommended treatments, the recommended treatment. No alcohol possession, 10 vehicle impound, 50 community service hours, attend a victim impact panel, pay court costs, cost of prosecution, and the $50 public defender application fee, as well as $50 for services. Mr. Vicente and myself have signed a plea form if I may approach.
May.
Was that a 12-month driver's license?
Yes,
application?
and shall early term at 6 if all conditions are completed.
Your Honor, the plea offer in this case is correct.
Thank you, Ms. Bonilla. Ma'am, will you raise your right hand to be sworn by the clerk?
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Will you state your name?
And so,
Ms. Vicente, your attorney has indicated you wish to withdraw your previously entered plea of not guilty, enter a plea of no contest, and accept the state's offer to resolve your case today. That offer, again, is an adjudication of guilt. You'd be placed on probation for a period of 12 months. You may apply for early termination after serving 6 months, provided you've satisfactorily met all conditions. A $500 fine would be imposed. There would be a 12-month driver's license revocation. You must complete the appropriate DUI school, 1 victim impact panel, a 10-day vehicle impoundment, 50 hours of community service. There would be a no possession or consumption of alcohol provision. That means you cannot consume alcohol while you're on probation. You cannot have alcohol in your home. You cannot go anywhere that primarily sells alcohol, such as bars, taverns, saloons, or packaged liquor stores. You must undergo a substance abuse evaluation, follow all recommendations, and you will be subject to random testing at your own expense. All court costs, including costs of prosecution and public defender fees, would be imposed. Is that the offer you wish to accept today? All right, I'm going to let Ms. Bonilla ask you some questions.
Can you state your name, please, for the record? You've been charged with fraudulent use of first-degree misdemeanor, which carries 180 days maximum jail sentence. Do you understand that that is the jail sentence? To that charge, how do you wish to plead? Guilty, not guilty? Did you understand the terms of the plea agreement? Have you read and signed a copy of the plea form? Do you understand all the rights listed on that form that you will be given up by entering this plea today?
Yes.
Are you entering into this plea because you believe that it is in your own best interest? Are you currently under the influence of any drugs or alcohol?
No.
Are you currently taking any medication? Do you suffer from any mental health illnesses? Have you discussed the terms of this plea agreement and the rights you are giving up with your attorney? Are you satisfied with your attorney's advice? Do you understand that if you are not a United States citizen, you may be subjected to removal or deportation as a result of this plea? Do you understand that if you are deported as a result of this case, it will not be a basis to withdraw this plea? Do you need any additional time to discuss any of this with counsel? Do you understand that driving under the influence is a municipal crime? Meaning that if you commit this crime again in the future, you could receive more jail or prison time, a higher fine, and or a longer driver's license revocation period. Your Honor, the state tenders the plea.
I'm pretty sure will you stipulate to venue and a factual basis for the plea?
Yes.
All right, ma'am, I'll accept your plea. Find it knowingly, voluntarily, and intelligently entered upon a factual basis and in your best interest, adjudicate you guilty and sentence you as previously stated. I'm gonna have you step over here to be fingerprinted. You'll need to check in with probation today before you leave the courthouse. It's located on the first floor. Thank you, ma'am. Good luck to you.
Judge, next would be David Norris.
Can you-
408.
All right, give us 1 second. Yes. I'm sorry, Ms. Armbruster, what case are we on?
20 and on 4, we use your David Law.
Thank you.
And procedure.
Madam Clerk, are you ready? Go ahead.
Your Honor, Mr. Norris would like to withdraw his previous motion to plead not guilty. He would like to enter a plea of no contest. The conditions of this plea would be for a withhold of adjudication, would be sentenced to 12 months probation, but shall early terminate at 6 months should its conditions all be met. He is to complete the ASC milepost theft course 2020 community service hours. No trespass with location of the offense, Madam State, that can have the address. And court cost prosecution and $50 public defender application fee and $50 for the process.
Such is all Walmart in Collier. And the fee offering, correct?
Do you
And
need,
our plea form has been signed by myself and then signed by my trustee.
do you need an opportunity to speak to him about that no trespass?
He was informed that I didn't inform him I didn't have a specific address on there, but that that information all in the county.
Okay. All right, will you raise your right hand to be sworn by the clerk?
Do you solemnly swear or affirm that the testimony you shall bear shall be the truth, the whole truth, and nothing but
Please state your name. Mr. Norris, your attorney has indicated you wish to withdraw your previously entered plea of not guilty, enter a plea of no contest, and accept the state's offer to resolve your case today. That offer again is to withhold adjudication, place you on probation for a period of 12 months. Probation shall terminate after serving 6 months, provided all conditions have been satisfactorily met. You must complete the appropriate AFC milepost shoplifting program, 20 hours of community service. All court costs, including cost of prosecution and public defender fees, would be imposed, and the court would order you not to trespass at all Walmarts in Collier County. Is that the offer you wish to accept today?
Yes, Your Honor.
All right.
I just have one question.
All right. What's your
Is
question?
there an opportunity for me to buy out the community hours?
Ms. Armbruster, Ms. Bonilla?
No objection,
All right. The court would allow you to buy out the community service hours at a rate of $10 per hour.
Thank you, Your Honor.
Any other questions about the offer?
No, Your Honor, I appreciate your help today.
All right.
This is our place.
All right. I'm going to let Ms. Bonilla ask you some questions, okay?
My name is David Antonio Norris. My date of birth is December 7th, 1972.
You've been charged with petty theft. As to that count, a first-degree misdemeanor. You do understand that the maximum is a year in the county jail.
Correct.
To that charge, how do you wish to plead? Guilty, not guilty?
No contest.
Do you understand the terms of the plea agreement?
Yes, I do.
Have you read and signed a copy of the plea form?
Yes, I do. Yes.
Do you understand all the rights listed in that form that you will be giving up by entering this plea today?
Yes, I do.
Are you entering into this plea because you believe that it's in your own best interest?
Yes, I do.
Are you currently under the influence of any drugs or alcohol? Are you currently taking any medication?
Prescription medication.
Do you suffer from any mental health illnesses?
No, I'm just on bipolar medication. But I'm in remission and I'm on medication and I'm feeling a lot better.
Is any of that affecting your ability to enter into this plea?
Not at all.
Have you discussed the terms of this plea agreement and the rights you are giving up with your attorney?
Yes, I have.
Are you satisfied with your attorney's advice?
Yes, I am.
Do you understand that if you are not a United States citizen, you may be subjected to removal or deportation as a result of this?
Yes, I do.
Do you understand that if you are deported as a result of this case, it will not be a basis to withdraw this plea?
Yes, I do.
Do you need any additional time to discuss any of this with your counsel?
No, I don't know.
Do you understand that petty theft is an enhanceable crime?
Yes, I do.
Meaning that if you commit this crime again in the future, you still receive more jail or prison time, a higher fine, and or a longer driver's license verification.
Yes, I do.
Your Honor, the state's under 16.
Ms. Armpriester, will you stipulate to venue and a factual basis for the plea?
Yes, sir.
All right, Mr. Norris, I'll accept your plea, find it knowingly, voluntarily, and intelligently entered upon a factual basis and in your best interest. Withhold adjudication, place you on probation for a period of 12 months, which shall terminate early. After serving 6 months, provided all conditions have been satisfactorily met, you must complete the appropriate AFC milepost shoplifter alternative program, 20 hours of community service, which you may buy out at the rate of $10 per hour, no trespass at all Walmarts in Collier County, and impose all court costs, including cost of prosecution and public defender fees. We're going to have you step over here to be fingerprinted. You'll need to check in with probation today before you leave the courthouse. It's located on the first floor.
Thank you, Your Honor.
All right, thank you, sir. Good luck to you.
Thank you.
Our next case is Mr. Ronald Emanuel, 1855. Your Honor, this case was set to me for status, so that I could represent the court if I was able to make any contact with my client, and to get both the state and my availability for potential trial dates.
Okay.
The defense does not have any conflict with setting this for trial. However, I've not been able to establish contact with Mr. Emanuel. There's a couple of different other layers to this case where I'm not sure a bench warrant is appropriate at this time, in terms of potential ADRs and motions to compel, just based on the probable cause affidavit being very vague.
Thank you so much.
It just makes it difficult to go forward. However, it also could lend itself to potential defenses in the future, but none of that's here nor there. Your Honor made this mandatory appearance from Mr. Emanuel, and I have not been able to establish contact with him.
All right, Ms. Bonilla.
Your Honor, the state would request that Your Honor consider issuing a bench warrant. This case has been on your docket since September of last year. It was ordered last court date that the defendant would be here today. He's not here. Defense counsel is obviously having issues hailing her client into court. So the state would just ask that you issue a bench warrant and that we address the matter when the bench warrant is served.
Brief response, Judge.
Okay.
While this case may have been open since fall of last year, our office has only been appointed since September. I would ask that the court take that into consideration, that he's only had counsel with Public Defender's Office. Our notice of appearance was entered on August 14th of this year, not last year when perhaps the case originally did come about.
Well, it does appear that the court previously issued a bench warrant for Mr. Emanuel's failure to appear.
I understand, Judge. I wasn't his attorney at that point. I've not been able to speak with him and express how I will be representing his case.
Okay.
But again, I understand the court's concern, and I understand why the court set this the way it did today.
Okay. All right. I'm going to order a bench warrant. The last bench warrant was an ROR. Any comments on bond?
May the defense speaker first.
You may.
Judge, I would ask that Your Honor issue a $500 warrant, being that the last was an ROR and that this is not dispersed. Being that the Public Defender's Office is appointed, he is financially indigent, and I would ask that Your Honor issue the warrant with a $500 bond and a court date with a notice to appear.
Judge, can you agree the recommendation to
All right. $500 bond on the bench warrant. I can't set a date, Ms. Armpriester. The clerk will set a date once the warrant has been executed. Okay. All right. Do you have any other clients in the courtroom?
No, Your Honor, actually, I don't believe I have any other clients on the docket if any needs to.
Did we cover Mullins?
Justin or Kimber?
Kimber Mullins, 20 MM24, set for a plea today.
Judge, I believe.
You filed the notice of plea hearing.
Judge, we have a moment to take this over.
Yes, you may. We'll recall it. All right. Let me go to Zoom. We've got a few people on Zoom here this morning. Thank you for your patience, those of you on Zoom. Let me go to Emily Hogentogler. Am I pronouncing that correctly? I'm sorry.
That was actually perfect, Your Honor. Good morning.
Good morning.
Your Honor, we've received an offer from the state. We've actually just accepted the offer from the state. So it's my understanding the state's not going to proceed this morning.
Can you tell me which case we're on?
Oh, my apologies, Your Honor. State versus Foreign Mihalov, 20 CT 2082.
Thank you. 20 CT 2082. Okay, go ahead. I'm sorry.
Your Honor, we've just reached a plea agreement with the state. I'm going to set it for a plea in absentia. My client is Romanian, so I do have to get the documents translated.
All right. Did you hear that?
Yes, I did, Your Honor. That is correct. At this time, based on the fact that the client will be entering a plea, the state would like to withdraw its motion to seek leave from subpoena medical at this time.
Okay. All right. The motion for leave of state's motion for leave of court to subpoena medical and EMS records shall be considered withdrawn. How much time do you think you'll need to get that plea in absentia?
I would say probably a month.
All right, do we want to set it for the January 29th criminal status motions docket?
Yes,
I think that would be sufficient time, Your Honor.
Ms. Hogan saying when your client will get the PIA.
She said she'd probably need 30 days because they have to get it translated into Romanian.
This case is currently set for January 20th.
Okay. All right, let's cancel the January 20th court date and set it for January 29th at 9 o'clock for a plea in absentia.
Thank you very much, Your Honor.
All right, thank you. Anything else?
Nothing further, Your Honor.
All right, thank you for your patience today.
Thank you.
All right, let me go to Mr. Carney.
Hey, good morning, Your Honor. Adam Carney with Verderamo Law on behalf of
Good
Juan
morning.
Pablo Grado Mendoza, 20 MM 1544. We're here to withdraw a pre-standard plea of not guilty, and we've got a plea of an absentia that's been filed.
All right, tell me the last name on the case again.
Grado Mendoza, Agredo Mendoza.
Thank you. This is case number 20 MM 1544.
Yep.
Looks like the terms of the agreement are withhold of adjudication, court costs, and costs of prosecution.
That's correct, Judge.
Does your client need some time to pay?
90 days would be great, Judge.
All right, I'll give him 90 days. All right. Give me a moment to review the plea and absentia form.
Mr. Carney on the phone?
Yes, it is. All right, Ms. Bonilla, have you had an opportunity to review the plea in absentia forms?
Yes, Your Honor.
Any objection?
No objection.
All right. Mr. Carney, will you stipulate to venue and a factual basis for the plea in absentia?
So stipulated.
All right, I'll accept the plea in absentia, find it knowingly, voluntarily, and intelligently entered upon a factual basis and in the defendant's best interest, withhold adjudication, impose all court costs, including costs of prosecution, and give them 90 days to pay.
Thank you very much, Judge.
All right, thank you, Mr. Carney.
Yep,
Have
have
a
a
good day.
happy New Year.
Happy New Year to you too.
Take care.
All right, let me go to Mr. Cantor.
Good morning, Judge.
Good morning.
And Your Honor, this is a plea in absentia. This case is worked out. My client has the plea in absentia packet. She hasn't gotten it executed yet. I just spoke to her. I anticipate I'll have the fully executed plea in absentia packet on Monday or Tuesday, at which point I'll file it. I would just ask to continue this out to the January plea in absentia date that you had given the previous attorney. I think it was January 29th.
All right, and this is on Cynthia Thibodeau, 20
Yes, Your Honor.
1385.
I apologize. Yep, Cynthia Thibodeau, 20 CT 1385, correct.
Ms. Bonilla?
No objection to a continuance, Your Honor.
I do have, we could do an earlier date if you wanted.
I would be fine with an earlier date as well, Your Honor. As long as I have all of next week, the following week, I should be ready to resolve it.
You want to set it on the pretrial conference date of January 20th?
That would be fine, Your Honor.
Ms. Bonilla, is that all right? All right, Madam Clerk, let's continue it to January 20th at 9 o'clock for plea in absentia.
Okay. Thank you very much, Your Honor.
Thank you, Mr. Cantor. Have a good day.
You too. Thank you.
All right, bye-bye. All right, that's all I have for now on Zoom. We want to go back to Ms. Woodley or Ms. Armpriester.
Sure, I said at 10 o'clock, if I can step out in a couple minutes. So I'm going to take the 5 minutes.
Sure, go ahead.
Thank you. Sarah Ryan is on docket 20 CT 211 She was working on getting her driver's license. I believe her second time for a free trial after the one final continuance. She should have a driver's license by the next 4 days. This case is relatively new, Your Honor. The state has no objection to a continuance.
Why did we set this on today's docket?
No, I didn't actually realize it was on today until yesterday.
I
I'm
think
not
we
sure
set it
about
on today's docket based on the other case she did have, but the state filed a no cross, so it was really a status for both cases to determine whether you were going to move forward with your motion to eliminate or not.
It could have been comparison on the other case.
Okay, I do remember it did have a companion case. All right, any objection to continuing it to the next pretrial?
No, Judge.
All right, Madam Clerk, let's set it for January 21st at 9 o'clock. All right,
Also have on the docket, Carlo Charlotte in SM 1331 that's set for status today. I think that it's continuing on this. He's done every court appearance. I was planning on setting this or asking for a bench trial today for this, but there must have been some kind of communication. He has not missed court. So if I could get continuance to just reach out to him again, I greatly appreciate it. He's very good about coming to court and keeping in contact with me.
this is one that we set here so that we could figure out a trial date.
For an interpreter and get everything squared away for a date.
All right, any objection to continuing it?
No, Judge, no. This case is currently set for
Set.
trial the 21st.
Okay, let's leave it on January 21st at 9 o'clock. You might just have your witness availability for the entire month of February, and we'll find a time that it'll go on.
Perfect, thank you.
Half a day.
So with an interpreter probably.
Okay. Okay.
then the only other person on the docket for me would be, a competency matter. It's 20MM1060 Azord. It's not in my name, I don't believe. Actually, it is now in my name. Okay, so we get 20MM1060 Azord. There was I could give this to the state attorney, I'm not sure if it's going to be Mr. Stewart or. This is a copy of. And then Your Honor, everything. Thank you.
What are
I'm asking the court to rely on Dr. Collins' competency evaluation where he did find him incompetent. So I'm asking the court to rely on his findings.
Want to put on the record why this was ordered or where it was ordered?
Oh, yeah, sorry. This was in Lee County. His attorney in Lee County, back in November, it was a few weeks before November 4th, had concerns about whether he could talk to his clients and had concerns on whether he could understand. This was going back and forth with clients, so then an evaluation was done by Dr. Collins on November 4th, I believe. Yes, November 4th. And Dr. Collins did find him incompetent to move forward.
Was this a misdemeanor case, a felony case?
A misdemeanor.
Does your client have any pending felony charges?
He does not. He in Collier County just has one misdemeanor case.
What about in Lee County?
And he does not have any Lee County cases. May I take a short recess of 10 minutes?
You may.
Thank you so much.
All right, we'll recall your case.
Judge, you can recall this for the moment.
Okay.
Your Honor, my notes reflect that we also set this for January 21st as a new date for a pre-trial, and then I did file a notice of hearing. Shortly after I filed that notice of hearing, Ms. Mullen reached out to me, and she came down with symptoms that she thinks are the flu, but also could coincide with coronavirus. So she's waiting on her test results. The last I heard from her, she actually sent me a message on Christmas Day. She hasn't received her test results. So and it just slipped my mind that I informed her not to come until we knew that she was healthy enough to do so. So if we could set this, the 1/21 pre-trial date is fine, or if the court wants to set it for another in-person plea date, that's fine too.
And then have the case number.
Yes, 20MM24.
20MM24.
Yes, I have had contact with her. I spoke to her on the phone. I can verify she's not well.
All right, it's currently set for January 21st at 9 for a pretrial. Any objection to leaving that date remain set?
No objection, Your Honor.
All right,
We marked as the last one.
I think it was marked that way already. All right, so we'll continue it to January 21st at 9 o'clock. All right, thank you, Ms. Armpriester. think that was your last case.
Now maybe.
You may. Thank you. Have a good afternoon.
You as well. And I believe I will see you at 2:30 for a plea. And I don't believe there's anything else I could cover for Ms. Woodley. We had already discussed it, but I know she'll be back shortly.
Okay. Did my judicial assistant reach out to you both regarding the motion to set aside the bench warrant?
The notice is being filed.
All right. So we are going to hear that at 2:30?
Yes, Your Honor.
Okay. Thank you.
I'll be appearing this soon.
Okay. I'll make sure to set it up and have my
Your
assistant.
Honor, prefer me in person or on Zoom. I don't have a preference for this hearing.
It's totally up to you.
I will get back to you.
Okay. We'll let you know if we're going to be in here or a different courtroom.
Lovely. Thank you.
All right. Thank you.
I can't do excuse your honor because I'm waiting on another matter with Ms. Woodley. I'll
Okay.
be here right now.
All right. All right. We've got another attorney via Zoom. All right. Let me call on Mr. Amster.
Good morning, Your Honor.
Good
I
morning.
apologize, I was using an old number.
That's
The
okay.
old Zoom number.
All right. You're here on Alexis Barkley, case number 15 CT 3122.
I am, Your Honor. Stephen Armstrong on behalf of Mr. Barkley. Your Honor, yesterday I filed a very late motion to continue. I was speaking with Julianne and she said that your next available date was January 19th. The reason is I contacted my client yesterday. My secretary, I have one secretary out on vacation, the other one in the hospital. So I'm kind of muddling through myself. I contacted Mr. Barclay to remind him about court tomorrow, that he needed to be present to take the plea. And he said that he had left me a message, which I did not find or receive, but he said that he left me a message that he apparently works in a gas station down here in Miami, and he's the only employee scheduled this week, and that if he leaves his post, he'll be fired. And I did not get that message, or I would have filed a motion much sooner. I tried to reach out to Mr. Cabrera, but it was too late in the day. So Julianne said I needed to appear this morning.
All right. And we have Ms. Bonilla here from the state. Ms. Bonilla. All right. Do we want, Ms. Bonilla, do we want to set it for January 19th for a plea?
May I inquire with defense counsel on whether his client will have the plea extension available at that time?
Well, are you going to do it, Mr. Amster? Are you doing a plea in absentia? Or are you going to require? Are you going to have him come over?
No, I mean I can have. I thought we had filed the plea in abstention, but I can have that in. You know what? I promised you I was going to have that last time, but I was going to physically have him come in so he could at least find out about the work, the weekend work, and maybe do whatever he needed to do while he was physically there. But I can do it a plea in abstention, and I mean this week.
Right. Go ahead and set it for January 19th.
Okay.
At 9 o'clock. Mr. Amster, if your client's not present and no plea in absentia has been filed, and good cause is not shown why he's not present, a bench warrant will be issued for his arrest.
Yes, sir. I understand.
This case is from 2015, and that's all I'm going to say.
I understand completely.
All right. January 19th at 9 o'clock for a plea. Thank you, Mr. Amster.
Thank you. Have a great holiday, everybody.
Thank you, you too. All right. We have not addressed Meadowline Charles, have we?
No, we don't know. That's a motion to expunge.
Right. The court's going to take a brief recess, and then we'll resume with State v. Torelli. We'll see if Ms. Woodley's back on State v. Azard, and then I'm going to have my judicial assistant check with Mr. Raheb to see if he's going to join us via Zoom for State v. Charles. All right.
I'm not sure this is gonna be. You were lucky enough to.
What's the Azor thing?
Yeah.
Okay, I'm familiar enough with it. Yeah.
All right, so we'll go back to Michelette Azord, 20mm1060.
And thank you for the court's time, I really appreciate it.
What's the state's position on the defendant's motion to adopt the competency evaluation in the Lee County case?
We weren't objecting. We agreed to it several weeks ago.
Okay.
Found ourselves in hearing nonetheless.
And I can shed some light on that. Whenever there's a competency, then for a case, if it goes in above me, suppose we have Nicole Calderon handles it. She requested that this be a 5-minute hearing and sent me over a proposed order. And it is a stipulated motion / order. I don't know, Mr. Stewart, if I actually sent this to you or not. If I emailed it to you, it would have been a cold email.
Actually, I'm starting to have some memory flashbacks here. I think
We have templates that that has the proper language.
what's this case number?
To be honest, it's a
2010-60 and
So I do have a proposed order judging defendant incompetent to proceed in setting case for a status check for June 10th, 2021.
Yes, that should be the right one.
Have you seen this proposed order, Mr. Stewart?
Probably,
Let me see if I can print it.
The updated one that the hotel room has a little bit more information. Did you find it?
I really don't care, so I'm fine with this, but this is done in a stipulation form, so I can say.
Oh, I didn't even find it actually. It contains a little bit more information, like 2 sentences more. I didn't appreciate it.
You may.
Thank you.
All right, I am signing the order granting the stipulated motion requesting a finding of incompetence and setting the case for a status check. And so we'll set a status check for June 10th, 2021 on the pretrial conference docket. And Madam Clerk, there's the evaluation. All right. Anything else, Ms. Woodley?
That is it for me. Well, for here anyway. Here, see.
All right. Thank you, Ms. Woodley. Have a good day.
Thank you. Have a good day.
All right. And that leaves us with Mr. Roy Stotcher. Do we know where he is?
He told me he had to go to different court. Get a felony, DOT, some sort of felony case, and then a case of just burn.
Yeah, POPs this morning.
All right. And it's my understanding that he is also covering the case on the motion to expunge and 19 MM 554. All right. This will be in recess until Mr. Roy Stotcher returns.